So today, my brother Justice Shivsankara Gowda is demitting office. So on behalf of myself and on your all of you, welcome to the bench and wish him a very happy, healthy and fulfilling life. Yes.
Thank you.
Yes.
Fresh matter.
What is the urgency?
Appellant is a state government company. Madam, the appellant is the state government company and respondent is a private limited company was allotted an industrial site. for purpose
21st
of
February.
My lord, mentioning,
Acknowledgement.
my lord, contempt matter, my lord. It is a contempt filed by the wife as against the husband, my lord. There was a 498 case that was registered by the wife, which came to be quashed before the High Court based on a mediation settlement agreement that was entered into between the husband and wife. After the case was quashed, my lord, the husband has not complied with any of the terms with respect to the mediation settlement agreement. So I request for a date in February, my lord.
Appeal.
Contempt, my lord.
Contempt. 10th February.
I'm grateful, my lord.
My lords, the government is building a small dam in Uttar Karnataka district, and nearly 100 farmers are getting displaced without any rehabilitation or any compensation, my lord. So
Yeah, you on
they've
yeah.
started the construction last week, my lord, hence there's urgency.
17th March.
In February, is it possible, my lord?
17th February.
Then you mentioned through EC, sir?
Yes.
Permission, the contempt matter, seal number 1, Mr. B. Ramesh.
For the complainant. Was order passed by the London single judge, where malas the respondent has challenged the order passed by the assistant commissioner. Malas, where the assistant commissioner under the Senior Citizenship Act, malas had directed the respondent to pay a sum of rupees 6,000 per month and also to malas, so permit the complainant to occupy the front portion of the building. Malas, this honorable court had passed an interim order on 7/6/2023, where malas to direction is given to the police to implement the said order. Lord, subsequently, malas, the respondent had sought to withdraw this writ petition with the liberty to file an appeal to the deputy commissioner, malas, under its order dated 3/6/2024. Malas, while passing an order, malas, this the London single judge had directed to implement the order passed by the trial, malas, so the interim order in the last paragraph 3, malas, page 45. The interim order passed by the honorable shall continue in force. But till today, malas,
What was the interim order?
malas, 6,000 per month has to be paid to the mother-in-law, and she was permitted to occupy the premises, malas.
Where is that interim order?
Malas, page 41, malas, annexure E. The respondent police.
The order of the assistant commissioner.
Assistant commissioner is in question.
Page.
Page 39, operative portion, malas. Sorry for this.
But it is that interim, which interim order is continuing? Interim order passed by this court shall continue.
Yes, malas. That was to implement the order passed by the assistant commissioner, malas. Malas, there is a direction. The respondent police is directed to give effect to the.
Okay.
Much of it.
25th March, February.
Much of it.
Seal number 2, Mr. Srinivas K.
What's happened for the complainant? 75 days. But issuing of cash certificate by the Tahsildar. The direction issued by the Sambu Court Malad is that annexure H Malad page 48. The operative portion of the order Malad is at page number 54 Malad.
The matter is remitted back to the hands of the Tahsildar to pass appropriate orders in terms of the procedures.
No time limit is fixed.
Pardon.
Certain lords. Certain lords, whether the petitioner has made a representation to substantiate case before the committee, my lord. That is the observation given by the honorable single judge. Lordship, if you see page 41, para 9, my lords.
It was not referred to the committee at all.
Alala.
The Tahsildar himself
Tahsildar himself, my lord. The
had given the
Tahsildar issued an endorsement without conducting an
We take
inquiry.
back to the hands of the Tahsildar to
permitting
pass order. Terms of
Petitioner
the
to
procedure, section 4 and
burden upon the applicant
Input of the
petitioner to
observation.
demonstrate, my lord, that are asserted.
No time is fixed.
no time is fixed. The following directions are made subject matter of contempt jurisdiction. Following directions in order dated 8th February 2022, on a single day. While allowing the petition in part are made subject matter of the contempt jurisdiction.
My lord,
Page 54, quote 3. On bare reading after quoting. On bare reading of the aforesaid observations, it could be seen that on a single judge is not described any time limit for the purpose of compliance. In that view, it is not possible to conclude at this stage that any of the respondents have committed contempt, or much less a willful contempt of the court. However, at the same time, the directions of the court should not go uncomplied with. Therefore, it is provided that the directions shall be acted upon and complied with by the authority concerned within a period of 6 weeks from today. With aforesaid observations, the contempt petition is not entertained and disposed.
Still number 3, Mr. Ravi Shankar. sir.
Complainant, my lord. There was a undertaking before the learned single judge, my lord, to conduct the election to the board, my lord, within 3 months. Section B was the undertaking given, my lord, on 1/2/24. Now, my lord, on 25/1/25, my lord, they have conducted the election belatedly, my lord.
Not conduct.
Now conducted,
Conduct. So,
25/1.
Election conducted, my lord.
in fact,
Result is to be announced because.
so we
they
are saying that after the time limit conduct.
Time limit and, my lord, 3 months was undertaking given before on 1/2/24. They have conducted, my lord, after filing of the contempt petition.
So what is contempt then? It is except not observing time limit.
Yes.
There is no contempt.
Election conducted, my lord. Subsequently, they have filed another set of petitioner
Addition
filed a
to the
writ
order
petition.
of learned single judge dated 1st February 24 was to conduct the elections of the management to work of
Please, my lord.
the stipulated time of 3 months. The contempt is alleged paragraph in respect to the said direction. However, it could not be treated by learned advocate, so and so forth, the complainant that the elections are now completed.
On 25/1/25,
On
but result is not yet announced, my lord. Election was conducted on 25/1/25.
25 and 25.
Because of stay, my lord.
How is it?
Because of stay, my lord.
Which-
Subsequently, petitioners filed a writ petition.
Not petitioner, my lord, some other.
There are set of.
However, the results are not declared in view of the stay granted by this
Yes.
court. In a
Listed on
petition-
fifth
In a
of.
petition filed against the order under contempt. Full stop. In any way, where mere non-observance of time limit does not persuade the court to initiate any contempt proceeding, inasmuch as the doctrine of substantial compliance will apply. The contempt petition is disposed of as not entertainable.
My wakalat name, filed wakalat, my lord. For
Honorary
Arman.
advocate Ms. So and so is permitted to file his wakalat on behalf of respondent number
1 and 1. 1 and 2. 1 and 2.
within 1 week.
Filed.
Within 1 week.
Wakalat filed. Filed, man.
Still number 4.
Please, my lord, I appear for the complainant, your lordship. May I please, your lordship?
Yes.
My lord, annexure A, ink page number 9, your lordship. It is an order passed by the honorable court. Operative pair of the order, my lord, is in ink page number 11, my lord. there is a direction of the Honorable Court to consider the representations within a period of outer limit period of 4 weeks, Your Lordship.
Notice written about
Grateful.
25th of.
Grateful.
Still number 5, Mr. Srinivas K.
Complaint. This is my lord regarding sanction of increment, my lord, to the complainant for the last year of service rendered by him. The matter, my lord, has been heard by this Sambu court also, my lord, and the order passed in the writ petition was upheld by this Sambu court by the annexure
So
D.
any amount is paid or not?
They have not yet, my lord, paid the, my lord, they sanctioned the increment.
Notice 25th of February.
Still number 6,
The petition complaint,
KP Bhuvan.
there is a direction from the Honorable Court in page 17, my lord. 4 months time has been given by the single judge, my lord. Until today, they have not taken any steps, not passed any order, my lord, on the representation.
Twenty-fifth February.
Accepted.
Still number 7,
Petitioner's
Mr.
complaint.
Lokesh KV.
There was an order by this Honorable Court directing the accused number 1 and 2 to deposit certain amounts for in pursuance of an order for after regularization of the loan. The notice was issued by the bank, but they did not comply with the order of the court. And the amount is more than 7 crores, though by virtue of the order, the account needs to be regularized, which was considered as an NPA previously. By virtue of this order, they get a benefit of regularization, but they don't deposit as per the direction of the court. The Honorable Court directed 2 weeks for them to deposit. We issued a notice notifying this is the amount for regularization. Till today, they have not come forward to deposit that. Page 30 may kindly be seen, my lord.
Last paragraph, Roman small 5.
Even for regularization, they need to pay a certain amount. That they have not done. That is prior to that Roman letter 4 may kindly be seen, my lord. They have not complied that condition itself. Only thereafter this will kick in, my lord.
After regularization.
Please, my lord. To regularize, they need to deposit that
The
amount.
loan amount after regularization.
Very well. But they have not even deposited
Then
that.
you take action. That's all. But even if it is, the amount towards regular is not paid.
They have not made that amount to regularization. So they fail that they lose that opportunity of regularization. Only then the condition number 5 will come in. So accordingly, as per the direction, we issue a notice. Notice at page number 14, asking them to deposit amount so that they can go ahead with that.
Following directions of Lana Single Judge in order dated 30th October 24 by disposing of the writ petitions are brought under the contempt jurisdiction. Report the entire operative order up to 1 to 5. Full stop. Learned advocate for the complainant, Mr. So and so submitted that the petitioners have not deposited any amount, including the amount towards regularization of the account. Therefore, contempt of the directions after contempt of court is committed. Full stop. The court is not inclined to accept the submission in as much as it could be readily seen that the court has provided and clarified that if the petitioners fail to repay the loan amount after regularization of the loan account, the respondent bank shall be at liberty to initiate the appropriate proceedings. Full stop. Non-payment of amount towards regularization of the account shall also entitle the bank to initiate the proceedings as permitted by the court. Full stop. In that view, it is not possible to conclude that any contempt is committed since the bank has remedy, applicant bank has remedy to enforce its rights. Paragraph. The contempt petition is not entertained accordingly. Same. Next is same.
Same.
Both same. Identical order.
Still number 9, the Shivshankar Vaidi. Still number 9, the Shivshankar Vaidi.
None is present. Stand over. 11th February.
So number 10.
I'm for the
Jagdish
complaint.
Shastri.
Complaint is working in the Moraji schools as a teacher, my lord. Court has granted interim order, my lord, on annexure page number 16, my lord. My lord, not to disturb, my lord. In my place, my lord, some another teachers are posted, my lord, which is a contempt lordship. Annexure 16. Similar situation, this court has granted order, my lord.
The transfer.
No, that not the disturb me, lordship. Disturb me.
You are
Posting.
transfer. You sent elsewhere.
No, I have not sent anywhere. They removed me, lord.
That's respondent number 2 is the competent authority. They are represented by an advocate. So now notice has to go to.
19th February. Service by end delivery.
Lordship.
Service by end delivery, since you are out of service. You want service by end delivery?
Yes, lordship.
Service by end delivery is permitted.
Still number 11. To Chidambar GF.
Arrested housing of the award in 3 months' time. What happened, my lords, the land was acquired by KADB by a notification issued after 1/1/2013.
The compensation, they affected the TS of 10%. For directed, the TDS shall not be accepted, it has to be.
Great. 25th of February.
Writ appeal. Still number 12. To TP Mutana.
I appear for the appellant, my lord. The appellant is the owner of that 46 flat constructed by the housing board in the year 1957, and the owner of the land, my lord. And in this case, my lord, that the honorable governor, Karnataka, as per the decision at the time, 2009, issued a guideline stating that all these flats which were occupied by the workers at the time, it was a quarters, and may be given to them on some sale consideration. And against that, that appellant corporation wrote requested the government, because that quarters are required for a new one silk weaving unit constructed in the same place, and that is why it is not possible to sell this property to sell these houses, 46 houses to the workers. Then, my lord, this matter was the matter before came up before the learned single judge, my lord. Your lords may kindly see page number 43, my lord.
Then what is wrong with this order? Why you are in a?
No, my lord, now the honorable governor has withdrawn that order.
Which?
As per the decision, as per the recommendation of the.
But you are only permitted to initiate the inquiry and conclude within.
That is correct. That has been stated by lord. Because against that issuance of the notice for vacating the quarters, they filed the writ petition. This writ petition, my lord, this writ petition came up for hearing, and this honorable court, page number 43, my lord, made this observation, my lord. 43. Para number 6.
43.
43.
43.
On 1/8/2024, this court, after hearing the parties, had sought clarification from the learned HCGP regarding the status of the government order dated 28/2/2009. This is the order, my lord, as to whether the same was still in force or had been revoked. The learned HCGP, on instruction, submits that the said order is still in force. However, he hastened to add that the matter is pending consideration before the cabinet for further consideration. Now the cabinet might decide in November, and as per the recommendation of the cabinet, this honorable governor has withdrawn the order.
Before comes said in the industries, they are the not the corporation and factories. The government has installed there are out to according to this order has been withdrawn in 24 hours.
My lord, that order has been withdrawn on 28/11, my lord.
Now this order has been withdrawn.
And that order I have already produced, my lord.
That order of withdrawal of the government.
Government, that I have produced my, that is I produced it before this honorable court, 2nd December. At last the order, my lord. That order is page number 11.
Yeah, last time ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ನೋಡಿ government order last. Government order.
I will say that according to, as per the statement made by learned referee, the appellant, ordered dated 28/2/2009, referred to by learned single judge in paragraph 9 of the impugned judgment and order, has been recalled and cancelled.
28/11
Has been withdrawn. It was submitted in that view, the subsequent directions would not survive. Notice returnable on.
And
I
Take
think
and-
this, if he is right, then nothing will survive.
Yes, my lord, I will also secure instruction.
Returnable on 3rd March, looking to the compass of the controversy presently indicated, comma, the appeal to be listed at 2/3.
my lord, stay may be granted, my lord. Every day, these 46 persons are coming and
What stay? You don't initiate the.
this order.
That order itself has withdrawn by the government.
Yes, ma'am.
Where is the question of implementation, sir?
Seal number 13, the writ petition. Ganapati.
This case, the lordship directed to my lord conduct survey and as to whether in survey number 128, my lord measuring 2 acres, my lord has.
Survey is conducted, my lord. Joint survey in the presence of the complainant or by the revenue department. Reports have been obtained, my lord. I will get it filed after serving a copy to my learned friend.
It was stated by learned additional government advocate, Harish, that
Overlap again, overlap.
pursuant to order dated 15/1/25, survey has been conducted. Full stop. He prayed for time to place on record the report of the survey. When?
Date may be.
Earliest, any date, my lord, convenient to the court because report is
No,
ready.
19th February.
Faithful, grateful.
Much.
Number 14, the Srikanth MP.
Notes for appellant, note this is a matter which was considered by your lordships. This is, my lords, where I challenged the order of the regional authority who directed that, my lords, I be paid salary, my lords, as paid to the other employees, contending that, my lord, the salary has to be paid in accordance with rules. Before the learned single judge, my lord, it was contended by the side that the provision is, my lord, held to be unconstitutional. However, it was my contention that, my lord, it has been stayed by the Honorable Supreme Court. And in spite of, my lord, observing that it is stayed, unfortunately, my lord, the learned single judge holds that, my lord, it has been only suspended from operation. Lords, on the last occasion, I was directed to, my lords, place on record the order of the Honorable Supreme Court also.
Judgment, so.
Please. The provision, my lords, which is held to be unconstitutional is at page number 78, my lords. Page number 78, small Roman 4, my lords, of para 28.
So then what is the effect? It is struck down.
It is struck down, but, my lords, held to be unconstitutional, my lord, is stayed by the Honorable Supreme Court. As is, my submission was that, my lord, the provision prevails. As the order itself is stayed by the Honorable Supreme Court, I am claiming benefit of, my lords, the provision. The learned single judge says, my lords, the provision cannot be made applicable. If lordships kindly see, my lord, the order of the Honorable Apex Court, my lords, page number 79.
This judgment of division bench of this court is stayed by so.
My lords, page number 79, I have produced the order of the Honorable Apex Court also. Learned single judge, my lords, accepts that. The observation, my lords, of the learned single judge at page 36, my lords, para 5. Last, my lord, in para 4, he observes that it is, para 4 also, my lords, the provision is, my lords, it is observed that it is stayed.
One submission, my lords. I am appearing for respondent number 5 and 6, the institution concerned.
Find out the status of the matter with the Supreme Court.
Not
Lords,
yet listed, my lords. Not yet
Not
listed.
listed, my lords, after the interim order was granted. As on today, my lords, interim order is in force.
You are seeking benefit of some salary.
Rule 3B, my lords, of the rule stipulate,
Which
it
says
shall not
that-
be lower than the minimum of the basic pay.
It
And
says
claim
that-
benefit of the provision.
It says that the salary has to be paid on par with the government
no.
teaches.
Earlier, my lords, on par, as per rule 3B, minimum, at least the minimum of the basic pay, my lords, is the provision. That is held to be unconstitutional by my lord division bench.
When it is pending, certain courts, I should be answered. Appeal is admitted.
Please.
It shall be listed for final hearing.
But one submission that I would just like to.
Second April.
One submission, my lords, one submission. With regarding that distinction with regarding that stay and the squashing, I'm
We have
really.
tried to balance the things,
Please,
not
my lords.
granting relief
Oh, obliged,
and
obliged,
admitting the appeal.
obliged,
because Supreme
obliged,
Court
obliged,
stayed.
Can I,
obliged.
lords, if I'm permitted, lords, if problem, lords, if it is admitted, lords, it may not reach, lords, if.
If you don't want it admission, then simply.
Lords, lords, have it.
Then I will
so
have to
that-
say that in view that SLP is pending before the
No,
Supreme
the
Court.
difficulty is now I am, my lords, retired also, superannuated, my lords, I'm only dependent on what I.
So we'll decide whether you are entitled to salary when there is no order of entry.
Please,
That will be admitted. What is it? You don't want? Then simply stand out to second April.
please.
Number 15. To Sadanand G. Shastri.
Copy for the petitioner here.
Reply is filed or not?
My lord, it's a passport authorities who have to
the
make a
Dispute
submission.
is in nature, civil nature, my lord. He is seeking relief of declaration that it is BBMP land that we should be encroached. Lord, these things cannot be gone into public interest litigation in a writ petition.
Some playground is.
Yes, my lord. In fact, the state government has handed over land to us. Initially in 1993, it was handed over. Subsequently, there was an error in the survey number. Lord, please, I have filed my statement of objections. 1911, 1994, approximately 3 acres of land, that is 2 acres, 36 kuntas were handed over. Originally, it was, the government thought it is survey number 61. Later, in 2023, a detailed order has been passed, rectifying the survey number. So I'm in lawful possession and usage of the land. We have constructed our office there. We have some vacant land where we want to build a new building for the Indian Council for Historical Research, ICHR. The BBMP is here. The BBMP has never claimed it to be their land. Now, how can the petitioner say that it is BBMP land? Till date, BBMP has not set up any claim against us.
So
And moreover, on the maintainability, the petitioner claims to be a trust deed.
Petitioners claim what? Petitioner says that it is a playground.
They claim that it is a playground.
BBM put the stand of BBM.
That's my oral instructions has never been a playground. It was in fact the larger parcel of land which was allotted by the government order to the
Put
PC.
something on affidavit.
Hello?
Put something on affidavit.
Yes,
Your stand will material.
I'll do that.
To put an end to the controversy.
I'll do that.
Great. Law and advocate, Mr.
Prashant.
Tan.
SH Prashant.
BBMP, Brahat Bengaluru Mahanagar Palika shall file reply
Yes, please.
making clear the stand of the BBMP with regard to the case put forth by the public interest petitioners that the land in question is being used as playground or not. Is playground.
Lord, one submission. The counter affidavit filed by the learned respondents, that's the Passport Seva Kendra, my lord. Their own document, it's a translated copy at running page number 43. They admit that they have sought for rectification of survey numbers. So blatantly, my lord, the admission is this, they're in the wrong survey number. Now they're trying to correct their position. The first grant for them, about 3 acres of land, was in the year 19.
Today passport office is functioning.
No, it is
Yes,
not there. They moved to Halsuru.
No, no, no.
No.
They moved to Halsuru.
Oh, no, that's wrong.
It's a regional passport.
But he's unaware of the fact, so therefore we can discount it.
And that
Back
apart,
to the
my lord,
NTB, my lords.
Let the baby.
yes, let them file. Another one aspect, my lord, is that there is an act, Karnataka Parks, Playfields and Open Spaces Regulation Act. Section 6 and 8, they're in complete contravention. I will also file my rejoinder to this counter affidavit. My lord. Week's time may be granted.
Now, on the maintainability of the writ petition, Lord, the petitioner claims to be a trust deed. There is no trust deed furnished. There is no resolution authorizing anybody to present the PIL. Lord, the PIL norms have not been followed. So therefore, Lord, I would be insisting on questioning the maintainability of the PIL itself. Last time also, Learned Counsel undertook to produce, but till date it has not been.
When shall we keep? First, 3rd March, 4th March, 4th
Great.
March, 4th March.
Shorter date, my lord.
Syllabus 16.
Shorter date if possible, my lord. Second week of February.
Will they be able to file within shorter date? 20th February.
Yes.
Highly authorized.
Syllabus 16. To Swami NBA.
We have filed our compliance affidavit in this matter, my lords.
Subject matter is the endorsement has been stayed by the writ petition, my lord. It is coming up on 5th.
They
maybe.
themselves have implemented
It is-
the implementation of the order
The
by
state
obtaining
selection.
the stay, my lords.
It will not survive.
It is, no, it may be taken up after 10 days because the writ petition is coming on 5th. It can be disposed after that. 16 and 17, both.
4th March.
Okay, much,
17 also.
both, much.
Syllabus 18. Ashok Banidini.
Delay,
The
Notices were only sent 22 days back.
service is incomplete.
notice is incomplete. Service has to be completed.
Appeal shall await the
2 weeks.
service on the respondent. Therefore to come up next
Date.
3rd March.
And Lord,
Much obliged.
copy of the writ appeal may be served on us, my lord, respondent number 3.
Respond number
3, my lord,
3. Give copy.
Yes, ma'am.
please.
Much obliged. Syllabus 19. Mr. Varadarajan MS.
That's violation of an undertaking given by him. Is what I am complaining of. Kindly come to page 31. Paragraph 3 of his affidavit. I submit that in terms of the joint development agreement, the builder developer has agreed to complete the construction of the entire building, including the 4th and the 5th floor in the suitable property, items 1 and 2 property in all respect as per the specifications mentioned in the joint development agreement. They agreed to hand over the owner's built up share, including the 4th and the 5th floor, are directed to be reserved for the appellants, so on. So this is the undertaking which is given. It's a 12-storied complex. That's except 4th and 5th. All other floors are completed and most of them are also sold away. This is reserved for me. He does not complete it. I have produced the photographs except the structures. Otherwise, no interior works, nothing is so done by him. He should complete it and then hand it over to us is the undertaking given by him. This is the violation I am complaining of.
My lords, I seek my lord's permission to produce synopsis, just to assist this court. Synopsis, my lords.
What's,
Lords, just to state the facts in a chronological way, my lords. because complainants are the daughters of the accused. So they have filed a suit. So this is a contempt petition filed by the daughters against their father.
This counter nowhere he says that this undertaking is complied with. He goes to the past stating that what happened in the original suit and all that. As far as this particular undertaking is concerned, he does not say that he has complied with it.
For which for?
Lords, may I take? Lords, may I take, my lords?
So you can go before the. This court is already reserved liberty. If any complications arise between the parties, directions may be sought for the trial court.
Please.
There is any further orders in the matter as far as the contempt which is apparent on the face of it. That should be taken cognizance of, my lords, by this court.
May I quickly take my? My lords,
Matter may have to go for inquiry where I will lead evidence to show that those 2 floors remain incomplete in all respects.
My lords, may I quickly take my lords to page
You have to
40?
file reply. You will have to file reply.
I have filed the reply.
Time up, where is that?
I filed the reply dated 2/12/2024. A detailed reply, my lords.
He has filed a very detailed objections, but nothing as far as my grievance is concerned. He never says that.
To that
is
effect, I'll
complied.
place my
The
submission.
undertaking is complied with. Nowhere has he said that.
Where is in your statement of objection, any reply to this para number 3 undertaking?
Please,
Which
please,
para?
please, my lords. My lords, may I take to page 47, that is the MFA judgment passed by the learned single judge.
So been a lady, statement of objection, where is we are mentioned about, replied about para 3 of the undertaking? Form of additional affidavit. For this para 3, where you are answered?
Please. Lords, in para 28 and 29 of my statement of objection. My undertaking, my lords, was only to the effect that I shall reserve the square feet in the 4th and 5th floor, and same shall be handed over to the appellants who are the pleasant complainants. If in case, if they succeed in the OS suit. That was the observation. And in fact, my lords, the order which they are misinterpreting was filed in MFA, and that IA, my lords, can be seen in page 53. 50, page 50, my lords, I'm sorry. They are seeking direction, direct the respondents to complete construction in 4th and 5th floor of the property, more fully described in the schedule. They are only seeking direction with respect to construction, my lords. And on the basis of this IA, considering my affidavit and additional affidavit, my lords, which is at page 56, I have attached in statement of reply, page 56. Page 56, my lords, is my affidavit dated 21/11/2022. In the very same affidavit, my lords, I have stated in paragraph number 8 which my lords may find it at page 59, wherein I have stated clearly, my lords. May I read, my lords, para 8?
I don't think succeeding what we have seen. Now I have received. No cut. Go to the गड़बड़.
Page 59, my lords, para 8. It's in my statement of reply, my lords. And in the very next page, my lords, para 6, page 60, one more affidavit in.
With the aspect that
I've just taken an undertaking that I will keep that agreed portion intact. And my lords, they are interpreting this order in a very different way, that I'll have to hand over the possession of that.
I am very sorry. that is not my grievance. Let's
Kindly look-
get the property only if I succeed in the suit. I know that. But what I am complaining is, he should complete that fourth and fifth floor also in all respects and then keep it ready. That's in case I succeed in the suit. And if he just hands over me only the structure without completing it, that's his undertaking is to complete fourth and fifth floor in all respects and then keep it ready to hand it over to me in the event I succeed in the suit. I am not asking him to convey the property today.
Even complete as it is, the other floors. So that you can seek direction and civil court also. So not entertaining. Sorry. For the rest of the thing, you are permitting you to go to the trial court as observed in the interim order. Yes.
Number 20, office objection with counsel submission.
Yes, madam.
The office objection that is raised is with respect to accused number 2, where I've said it's a principal conservator forest. That is the post that is there in that address.
That for the time being, office objections are dispensed.
Yes, yes.
Contempt
My lords,
petition may be
this-
listed on.
My lords, may I
13th,
make one
13th.
submission, my lords, if my lords may permit me? This matter, my lords, pertains to a surrender of forest land, which was done in 2016. Thereafter, my lords, the honorable single judge passed a very specific order to say from the to redetermine the compensation within a period of 4 months, which is still active today. So I'm not complaining on that. My simple grievance is, my lords, for a moment, if I may take my lords to page number 44 of my contempt petition. 44 minutes of my contempt petition has the order. The order passed by the learned single judge.
Listed on 13th.
Well, there's some, the urgency in this matter, my lords, is 2016, I've surrendered the land. And
listed on 4th February.
Lords, 4th. I'm grateful. Lords, may take, I'm grateful.